Okay. I would like to introduce our presenters today. We have Marion and Carlos from the Legal Project, and they're going to be giving us some information on U.S. naturalization updates for this current year. So I'm going to turn it over to them at this time. Thank you, Marion and Carlos, for joining us today.
You so much for having us. Um, I am going to introduce us a little further. We're from the Legal Project now located in Schenectady, New York. We've been in the Capital Region for 30 years. Carlos and I are both funded through the New York State Department of State Office for New Americans. Um, and we serve the Capital Region and beyond from Schenectady. And we're going to be talking about some changes to the citizenship, the naturalization application process. Most of them were announced last year with the new administration. And I'm going to say that I gave this presentation earlier in the week and I went way over time. So I'm trying to move a little faster. And also I'm going to ask you to hold your questions. My email address will be on the last slide. I welcome emails with general questions. I won't be able to give specific legal advice, but happy to field general questions by email instead of during the meeting, just to try to be conscious that you might have to go back to class, back to work. So thank you for being with us, and get started. We're going to talk about the naturalization process. So the application process, I'm sure many of you are familiar with it from your students going through it or going through it yourself or helping relatives. Basic eligibility, some some caution there, and then getting into some of the changes in what it means to have good moral character, changes in the civics test, increased scrutiny in different areas, including in the N648 medical exception form. So let's get into that. Carlos, I think this is you.
Yes. So just as a general reminder to everyone, applicants should always talk to a lawyer before applying if they have any doubts about their eligibility or if they're not sure how the answer that they want to give to a question will affect their application. Applicants may try to withdraw pending applications, but USCIS doesn't have to agree to withdraw that application. Ultimately, it falls on the USCIS officer. It's under their discretion whether or not they want to proceed with the investigation or to withdraw the application.
Yes, this surprises people, but once you submit that application, you may not be able to to unring the bell, as we like to say. And with increased scrutiny, scrutiny on citizenship applications has always been high, but this administration has kicked it up a notch in ways that we'll talk about during this hour, and denial of an application could lead to someone losing their permanent resident, a process by which they could lose their permanent resident status, or a removal or deportation process, as we'll talk about briefly. So very important, if anyone has any concerns, any doubts, that they meet with a lawyer before they submit that application. And this is a reminder just for all of you who are helpful people and who are, figures of good advice and authority in the lives of your students. Just protect yourself. If you're not a lawyer, make sure that they know that you're not a lawyer when they're asking you questions. Licensed attorney or in the immigration practice, there's something called an accredited representative. If you're not in one of those positions, don't give legal advice. You could be opening yourself up to civil or criminal penalties. So make sure that your students know that you can't offer them legal advice. And the other thing I would warn, because this comes up all the time, people say, well, my situation is just like my neighbor or just like my brother, and they were fine. They're citizens now. And more than ever, we can't rely on that. People often don't actually grasp, what another person's case is like and whether their case is really similar, for one. And another, this administration is, as I said before, doing, more investigation, and finding harsher consequences for things than ever before, I think we can say. So just because it worked out for your neighbor or your brother doesn't mean that it will work out for today's applicant. So if anyone is not familiar with the process, this is an overview. The application can now be filed online or on paper. This is the N400 form. So an individual can create account online with USCIS and file the application from within it. They will have to pay the fees. They are a little lower if you're filing online because it's more convenient for the government. If you need a reduced fee or a fee waiver, though, you will have to file on paper. Um, if you, either way, you'll get a receipt notice back. The nice thing about filing online is if not automatic, you'll have it in your account within 24 hours. On paper, it could take a couple of weeks, for your application to get there and be processed in the mailroom and them to, cash your check and so on, send you back the receipt notice. They will also send you an invitation to create an online account if you didn't use one to begin with. So you often get that with the receipt notice from U.S. Citizenship and Immigration Services, or even ahead of it, the invitation to create the online account. And I have a picture on the next slide of what that's going to look like. Following that will be a biometrics appointment. This is for fingerprinting to do the background check. It's important to attend this appointment or to reschedule it through the USCIS website or by calling their 800 number before missing the appointment, ideally. This is something we're going to get into a little bit more in a few slides. An investigator may come to your home or your former homes or your workplace. And then you will be invited to an interview with USCIS. At the interview, you'll go over your application under oath. You'll take the tests that we'll talk about further and that I imagine many of you are familiar with. And you might get a decision on the spot, or you might be told that a decision will need to be mailed. You might receive a request for more information, either on the spot or by mail, and or a denial notice, I suppose. And if your case is approved, you'll be invited to attend an oath ceremony. You are not a citizen. The person is not a citizen until they have sworn the oath. So even if they were told at their interview that everything went well and their case was approved, they are not a citizen until they've sworn that oath. So that is an overview of the process. I know that in Albany, these were going pretty quickly, like within a couple of months of filing, the person would have their interview. I imagine that that's not the case in other parts of the state that are more populous, but they were moving really fast in Albany in the past few years. You are not already familiar, this is what a notice from U.S. Citizenship and Immigration Services looks like. The heading, this is how you would get a receipt notice or an interview notice. This particularly is to create an online account if someone didn't use one when they filed. So you can see in the upper left-hand corner the receipt number that's specific to this case. Above the applicant's name on the right side, there's a number that starts with the letter A. That's specific to the applicant. It's like the A number is like a social security number, but within the immigration system. It identifies the individual and is used throughout their applications, whether it's their green card application or their work permit application or their citizenship application. Okay. So I'm going to review some basic eligibility. for most people, they become eligible to apply for citizenship after 5 years in permanent resident status. I also may call that PR status. What it means is that the person has a green card. They are kind of green at this point. They haven't always been green. They were pink for a while. But that's what we mean. Permanent resident status, a green card, same thing. Um, we measure from the resident since date on the card. I try to be specific when I ask someone. uh, I try not to say, how long have you had your green card? I try to say, what is the resident since date on your card when I'm trying to figure out if they're eligible, because refugees and asylees both benefit from some amount of backdating. So when a refugee is approved for their green card, the green card is backdated to when they entered the country as a refugee. An asylee's card is backdated 1 year prior to the date that they were granted permanent resident status. So that helps both of those groups become eligible for citizenship a little bit earlier. And it confuses them when I ask, how long have you had your green card? Because it might not have been, it won't have been 5 years by the time that they are 5 years from their residence since date. I hope that was clear. Many people will be eligible after only 3 years if they can show that during those 3 years they were married to a U.S. citizen and were jointly residing with their spouse. So all three of those things need to have been during the 3 years. This does open people up to having to answer some questions, provide some evidence at the interview about their marriage. They'll need to show that their spouse is a U.S. citizen. They'll need to show that they've been living with their spouse the whole time. If their spouse, works out of state, is in school out of state, this could get challenging. So not everybody who's eligible after 3 years will want to go that route, but it is a possibility for those who are married to U.S. citizens. It just to be clear, if your spouse naturalized last month, you are not suddenly eligible. They need to have been a citizen for those 3 years, and you need to have been married for those 3 years. USCIS will not naturalize someone if they decide that they were not properly granted permanent resident status. So this is, I have seen denials where they say, we should not have approved you for a green card when we did. We now that we've scrutinized your application for citizenship, we realize that it was inappropriate to approve you for a green card. And that's awful, because that person is at best stuck, right? They can't move forward with citizenship because USCIS says they don't qualify, and they're at risk of USCIS trying to take away their permanent resident card. And it was not their mistake. Potentially, it was the government's mistake, but that does not help them. But I have definitely advised people it would be better for you not to apply for citizenship and have them get into these details. You might just be more comfortable living as a permanent resident than inviting that kind of scrutiny. The person needs to have been physically residing in the US for most of the last 5 years to be eligible for citizenship now. USCIS is going to add up the number of days that you've spent in and outside of the country, whether they were short trips or long trips. I have seen the denial letters where they have added up day by day the length of your trips. So that can be a reason to deny your application if you've spent more of your time outside of the country. But there's a lot of risk there also that the government says, well, do you really reside in the U.S.? If you're spending so much time outside of the U.S., maybe you're not a permanent resident here. So even if the person, let's say, came back to the U.S. every 180 days, thinking that was the requirement, the government could still say, it doesn't actually seem like you live here, and attack whether they should really have a green card at all. So that is a risk for someone who has spent a lot of time traveling or is living or working outside of the U.S. Other eligibility requirements for citizenship: having good moral character. We're going to get into this. There have been major changes in this area. Being able to pass the English and civics tests. I imagine that you are all familiar with that requirement, or those of you who teach English or teach citizenship classes. You'll probably know that a new test came out for people who applied after October 20th, I believe, and we'll get into that a little bit more later. And you will need to show that you support the U.S. Constitution. No change to that requirement, but you may be asked more about it. All right. So that is some basic eligibility requirements for becoming a U.S. citizen. Two acknowledgements that being eligible doesn't necessarily mean that your case is going to be approved. Right now, with the travel ban that was announced on about 40 countries in 2025, USCIS also announced that they were pausing adjudications of any kind, almost any kind of application for people from those same countries. There are a couple of types of applications that are still going forward. They're still accepting applications. They will still cash your check, but they will not approve applications, including citizenship applications, for people from those countries, with limited exceptions. I think you can still renew your green card, a few other things. Like I said, someone can still apply, can still get in line, but we are seeing that if you are a national of one of those countries, at least in Albany, interviews have been rescheduled, they've been canceled, sometimes by phone, which is, for a long time we've said if somebody calls you and says they're from USCIS, it's a scam. Might not be a scam right now if they're calling you to cancel your interview. Or some people are being interviewed and then told that no decision can be made. And sadly, some people who had made it all the way through the process and were just waiting for their oath ceremony, those ceremonies were canceled, or they were told not to attend. I imagine that some of you had students who've experienced each of these things because of the country they're a national of. So that's one situation right now where eligibility might not equal approval of the application. I wouldn't normally talk about deportability grounds, many of them in this kind of presentation, but we are hearing that with the increased scrutiny and with the USCIS policy of referring people to immigration court to see if a judge agrees that they're deportable, I think it's important to mention some of these grounds of deportability. Because a person might be both apparently eligible for citizenship, but also at risk of being referred to the immigration court to see if a judge will agree that they're removable from the U.S. So I'll run through these briefly, and if just to give you an idea of red flags that might indicate that your student should go and meet with an attorney. So certain criminal convictions will make even a permanent resident deportable. If someone has an order of protection against them and they violated that order of protection, specifically the parts that were protecting the person from bodily injury, threats of violence, repeated harassment, they could be deportable for that. Someone who unlawfully or violently opposed the U.S. government or engaged in activities that would have serious adverse foreign policy consequences. I'm thinking that might come up with certain kinds of criticism of the government or protest. If the applicant encouraged or helped somebody to enter the U.S. in violation of the law, so helped them, gave them money, encouraged them to do it, that could be considered human smuggling. Marriage fraud, so getting a visa or other documentation through marriage fraud is a ground of deportability. Someone who supported or engaged in terrorist activity is deportable And the word of caution here is that the terrorist group doesn't have to be officially recognized. If they just meet a pretty vague definition of what the government considers to be a terrorist organization, this might be applied to them. Um, Someone who failed to register with USCIS or failed to keep their address up to date when they moved while they were a permanent resident or in any other status other than citizen. I haven't seen that be used to remove somebody from the U.S., but it is in the law. If someone became dependent on the government within 5 years of entering the U.S. for a condition that existed before entry, that could lead to deportability. There have been some cases in New York City in the fall like that, I believe. I don't know if it's happened anywhere else around the country. This is what we refer to as public charge, and I know it inspires a lot of uncertainty and anxiety to raise it. So I will say that the government has not changed the rules around public charge, but we think that they are planning to do it, and it's drawing increased scrutiny, and it inspired the 75 country ban on immigrant visas. So it's definitely an area where we expect to see more changes. But historically, it has been very difficult to deport somebody on these grounds. Um, the government had to prove a lot of things, jump through a lot of hoops. So hopefully, I mention it because it's an area of some action and definitely increased interest of the government, but we have not seen a lot of cases like this yet. And then the big one for me always is somebody who falsely claimed citizenship, probably by accident, probably, on a DMV form or a workplace form that somebody else filled out for them, or who unlawfully voted. Some people think they're doing their civic duty and that the USCIS officer will be pleased to know about their voting. It is not legal to vote in a federal or state election if you're not a citizen. There may be some jurisdictions where it's legal to vote in a local election, but I would be extremely careful about that. So if a student of yours says, "Hey, I got a voter registration card," or if someone comes to your class and says, "We're doing a voter registration drive. I'd like to register everyone to vote," please urge them to be careful that registering to vote, voting, could all lead to deportation. Okay. And again, my email address will be on the last slide. I'm sure some of this inspired questions. You could email me. All right, Carlos, is this you? You are muted.
All right. So for the good moral character permanent bars, a permanent person with a permanent bar will never be able to naturalize, unfortunately. Uh, and the permanent bars to providing good moral character include having been convicted of certain crimes or responsible for persecution of other people.
Yes. So I was eager to get off the last slide, but let me give some context here. So I mentioned in the eligibility section that one of the eligibility requirements is showing that you have good moral character. And previously that has mostly been a question of, does the applicant have any permanent bars? Does the applicant have any conditional bars, which we'll get into next? Conditional bars will keep someone from being eligible for citizenship for 5 years. There are things like, this is not of the full list, but things like failing to support your dependents, having multiple DUIs or DWAIs, helping someone enter the US in violation of the law, being incarcerated for 6 months, being married to more than one person at a time, anything related to prostitution. So hiring somebody for sex, doing sex work, or getting money from sex work, or bringing people to the US to do sex work. Admitting to other unlawful acts or crimes involving moral turpitude, failing to pay taxes, admitting to a controlled substance violation or being convicted of a controlled substance violation with pretty limited exceptions. And this is my reminder that if you're not a citizen, I don't consider marijuana to be legal in New York State for you. It is still a controlled substance under the federal government's definition, which means that if you are going to be answering any immigration officer's questions, these are likely to come up and could result in denial of an application or in deportability. And then finally, and this is always really sad to see when we have consultations with people, they come in with a denial notice with something that is fixable, like they were denied because they owe taxes and they're not in a payment plan. That's something that they could fix and they could apply again, except that they are accused of lying about it in their interview, and lying under oath is a conditional bar, meaning that even if they got in a payment plan for their taxes, they couldn't reapply for the next 5 years. Um, let's see.
And just a little tip. So for taxes, if the applicant has not filed taxes or missed filing in recent years, they should file before applying. If the applicant owes state or federal taxes, they will need to show that they are up to date with payments and a payment plan. In regards to the supported dependents, applicants should show that their child support payments are up to date. If they don't have a formal child support arrangement but do support their child, they should provide a letter from the child's other parent confirming support or provide receipts. So in short, it's okay to owe back taxes as long as you're on a payment plan and making those payments. And showing a letter from a child support agency or the other parent is considered evidence confirming receipt of support.
Yes, I know that not everybody's in a formal child support arrangement, and not everybody's co-parent is going to provide them with a letter. So I think an alternative would be receipts of what you do pay for your child. Uh, if someone has been arrested, they're going to need to provide information about that and dispositions with their application. If they're not sure, what court they need to go to or how many times they've been arrested, or if, something would be considered an arrest, they should talk to an attorney. They may want to do a background check, like their own FBI history, to get a list of those and to make sure that they're not putting themselves at risk by applying. And then I'm going to keep hammering that false claim to citizenship a couple more times. So if someone has, by mistake or on purpose, been registered to vote, voted, claimed to be a citizen, they really need to talk to an attorney before they apply. Once again, really, really, really important. No false claims to citizenship. This can happen, like I said, this can happen inadvertently when someone is filling out, especially a driver's license application at the DMV, or, mortgage or DSS forms. So they just need to be careful about what they're signing, review what they're signing. And if they got a jury summons or a voter registration card in the mail, really important to get themselves removed from the voter rolls. Okay, so we're still talking about the good moral character eligibility requirement. And like I said before, the government previously focused a lot on whether the permanent bar or conditional bar applied to the applicant. But in 2025, they announced a new policy that really changes how they're assessing good moral character. They're now asking applicants to prove that they are worthy of US citizenship. These are the words from the policy. Officers are instructed to do a holistic assessment, like looking at all the factors, balancing positive and negative factors. They're going to look at whether the applicant is assimilated and what positive contributions they've made to society. Again, terms from the policy. So listed in the policy are a bunch of positive factors, which it's great. It's good to have some guidance there. Those are community involvement, contributions to the US, family caregiving, ties to family in the US, the person's length of residence in the US. Are they complying with their financial responsibilities and their tax obligations? Um, what have they attained in their professional life, in their education, and can they show a history of stable and lawful employment? So I've seen some reports from attorneys that that applicants are getting increased questions, but officers are not necessarily wanting to look at the paperwork that they're bringing in. Regardless of that, for reasons I'll get into in a minute, I would recommend that someone collect evidence of their good character and submit it with their application. So, um, if they can get a letter from their employer saying that they're a great employee and have been for many years, letter from friends and family or from their kids' school saying, you know, they come to their parent teacher conferences, or from the kid's medical provider. Um, we always have people bring in their tax information, but maybe you want to bring in proof of your excellent credit score. These are ideas of mine. These are not in the policy. But letters from friends and family, faith leaders, community leaders, if you've gotten a certificate for being, you know, volunteer of the month or employee of the month, if you have certifications of trainings you attended at work or diplomas, all of those would be things to collect that could potentially show your good character. And
So, sorry, a little update to the neighborhood checks. As of 2025, USCIS policy memo says that they will no longer routinely waive personal investigations of people applying for citizenship. So the neighborhood checks has always been law, but they until recently have been waived. USCIS may ask applicants for evidence of their good moral character, the commitment to the principles of the US Constitution, and their support for the good order and happiness of the country. This evidence will be used in determining whether the person is eligible for citizenship and whether USCIS needs to visit the place where the person has lived and worked in the last 5 years. And there's a little tip. This one, just to expand on what Marion was mentioning earlier, it's it's always a good idea to submit the evidence of good moral character with the initial application. This way, the officer reviewing the application may have the evidence that they need to waive an investigation.
yes, so even though I've seen some reports saying that officers haven't wanted to see the evidence that somebody brought in person, I think it's a good idea to submit it ahead of time, because if they're on the fence about whether or not to send an investigator to the applicant's house or workplace, maybe the evidence submitted with the application will um, tip them over into deciding to waive the investigation. Um, um, on that point, I don't know. As Carlos said, these investigations have been waived. I think the entire time I've been practicing, I don't think I've heard about one in a citizenship context. Um, and I'm not sure, you know, there were reports in I want to say December, November, December, of investigators going to citizenship applicants' houses in Minneapolis. I think those turned out to be fraud investigators rather than USCIS, you know, citizenship investigators. So it's if somebody knocks on the door, it could be obviously any of a number of branches of DHS. And I think that puts people first in the tough situation of, you know, do I need to ask this person for a warrant before I open the door? And second in the position of, if it's, if it's not ICE, it's just an investigator, do I want to answer their questions without having an attorney present? There's some fear that if you refuse to answer the investigator's questions, that might be, a point against you on your record. On the other hand, if you answer the questions without an attorney present, then you might also say something that damages your application, depending on your situation. So I'm not sure what I would advise as a blanket rule. I think it's going to be pretty case specific for applicants. All right, so I imagine that many of you are familiar with the testing requirements. At the interview, the officer is not just reviewing the application to make sure that the person is eligible, they're also administering reading, writing, speaking, and civics tests. And in my experience, they often start with those because they want to know before they spend a lot of time if the person, they're not gonna get into all of the details if the person can't pass the tests. So this is often where they start after they put the person under oath and review their IDs, and they get into the tests. The USCIS website, as I imagine you know, has a reading vocabulary list and a writing vocabulary list. So the person will be asked to read a sentence out loud. I think there's usually, if they struggle with the first one, I think they can be asked to try two other sentences. And all the words in those sentences will come from the reading vocabulary list. They'll be asked to write a sentence that the officer says out loud. It'll be made up of words from the writing vocabulary list. So they should practice how to spell those words. They should practice writing, typing, or with a stylus on an iPad, because that's generally how the test is administered. And that, as you know, is a skill unto itself, right? Not everybody has the same level of tech literacy or has those uses those tools at home or at work. So they may need to practice writing with a stylus or typing to be ready to, without anxiety, do the writing portion of the test. They should also practice. They should have somebody. Maybe it's YouTube, maybe it's you. They should have somebody say the words in the writing test out loud to them, so they know how to recognize those in an accent that may not be their own or their community's. Just so they're really familiar with how those words sound, not just when they say them in their heads. Throughout the interview, the officer is testing the person's speaking ability. So this, I think, is where a lot of people who have studied really hard could still fail the test. The officer, is paying attention when they ask the person to have a seat or stand back up and raise their right hand to be put under oath. Does the person quickly follow those commands? Do they recognize what the officer has said? And when they, can they listen to the officer asking the questions on the application? Maybe they'll be asking them in a different form than the way they're written. Can they follow the questions when they're rephrased? They may also ask the person, do they understand the question, or can they explain why they answered the question in the way that they did? And they may ask for a definition. I've seen officers ask people to define persecution. I would struggle to define persecution on the spot. I was fortunate that my client in that case, her sister had gotten the same question, and we had practiced. I've also had a client ask to define terrorism. These are the vocabulary on the actual application is a lot harder than the vocabulary in the reading and writing tests. Good news is nobody's going to ask you to spell persecution, but the bad news is that you need to be familiar with words throughout the application because you could be asked to define them, and many of us would struggle with that. um, Finally, the civics test. So um, the person needs to be able to answer 60% of the questions asked. And these are going to be randomly chosen. It's usually a computer generated list of questions from the list. The list has been 100 questions. The 2008 version of the test was 100 questions. It was increased in October, I think, to 128 questions. And right now, the applicants who applied before October are being asked 10 questions. They need to get 6 right. Applicants who applied after, I think, October 20th are being asked 20 questions and they need to get 12 right. Let me see if I have a slide about that. Yes. The questions are not, they're still the same subjects: geography of the US, history of the US, government. I think I noticed a new question about the Electoral College. The one about selective service might be new. What does it mean to register for selective service? I think I saw one, what was the first national motto? So they're still name an American innovation or a U.S. innovation. So they're still in the same vein in terms of subject matter, but there are more, and I'm sure I don't need to tell you this. You are the experts, but I usually encourage people to think about how they learn best. I've had clients who studied for the test by listening to someone read the materials. I've had clients study in their native language, and so that they could get a better grasp of the material. There there are flashcards. There's, I think, apps and YouTube videos. There's any number of study tools, but the important thing is the person do what works for them, um, as long as they're studying for the correct version of the test, the one that will be applied to them, and that they understand that it's not a multiple choice test when you're in the room. It might be a multiple choice test in the app, but it's not. You're going to have to come up with your own answers in the room, which is much harder. Let's be honest. Um, I think the final thing is there's a lot, there are many more answers to some of the questions than the person actually needs to come up with. So focusing on, does the question say I need to know, the name of one state that borders Canada? Great, like learn New York. Don't learn all the states that border Canada, because the question isn't asking that. So I think those are all the tips I usually give citizenship applicants. But of course, there are people who are very intimidated, who really struggle with the testing requirements. So for those who are over 50, um, there may be exceptions to the English requirements. So someone who's over 50 and has had a green card for 20 years, or over 55 and had a green card for 15 years, they don't have to do the reading and writing. They can bring their own interpreter to the interview. But the interpreter will be asked to interpret the civics questions and then their answers to the civics questions. So they still need to learn that information, and that's where studying in their own language obviously would come in handy. People who are 65 or older and have been permanent residents for at least 20 years, there's a specific short question bank. So they need to learn fewer questions. And again, they can bring their own interpreter. And then finally, there are people who, for medical reasons, will struggle to learn new information. So we're going to talk now about what option is available to them. That's the Form N648, the medical disability exception. Um, I was talking to educators earlier in the week who have students who, I think one of them said her student takes 9 different English classes a week and is still just struggling with the material for this test. Um, Carlos,
So,
is this you? Yes.
yes.
Sorry, trying to remember to
So
stop.
we're going to talk about the N648, the medical certification for disability exemption. The applicant may ask their doctor to complete this form to show that they have a medical condition that prevents them from learning new information, English or civics or both. The form is also used when an applicant is unable to answer questions regarding their application or understand the oath of citizenship. A legal guardian or certain relatives may answer for them, but it is important to note that illiteracy and old age are not qualifying medical conditions. And as of like with the neighborhood checks, USCIS is increasing their scrutiny of the N648s to detect fraud. Applicants are now required to submit N648 with their citizenship application with limited exceptions. So just some tips just to go about with the form. The applicant should go to their usual doctor. USCIS does not like it when the form is completed by a doctor who is only seeing the applicant for the sole purpose of filling out this form. For them, for the USCIS officer, it could throw up a little red flag for fraud. Another thing is the only certain types of doctors may sign the form. So MDs, DOs, or clinical psychologists. Other staff in their office may assist in completing it. So, for example, if the applicant is getting their physical done by an NP, the NP can draft up the diagnosis, but ultimately it is the MD who signs off on it that counts. And this has to be filed within 180 days of doctor's signature. It has to be filed alongside the N400. And USCIS is very picky about how this form is completed.
Sorry, you hit your mute button, Carlos.
Sorry.
Yeah,
Um,
and very
US,
picky.
yeah, they're very picky about how the form is completed. So it is very, very crucial that the applicant ask the doctor to be very thorough, but not complex. The doctor should use the language that a regular person can understand, and should be stressed to the doctor that the person that is going to be reading this is not a fellow doctor, but a USCIS officer who does not have the same level of medical expertise, and to always use diagnosis
Thank you. Yes. So this has always been a challenging form to get USCIS to approve. I have had success when the diagnosis was really clear to a layperson, you know, when it said Alzheimer's, when it said dementia, when it said brain injury. Um, you know, it was easy for a USCIS officer to understand why this person couldn't form new memories or learn new information. I have had forms denied where the person, you know, had a complicated medical situation, uncontrolled diabetes, depression, but the doctor didn't do a good job of, you know, convincing convincing the officer that the person couldn't learn new information because of these. As Carlos mentioned, it does not matter if the person is illiterate in their native language. It does not matter, you know, just saying that this person is elderly. Uh, the form can't be approved just for that reason. Um, some of you may have attended a training about this within the past month or so. I was excited to learn that some attorneys have had success with cancer patients if the doctor was able to say that the person's chemo or their response to the chemo drugs was making it challenging for them to learn new information. Um, the attorney who spoke said that they have had success getting USCIS to accept that as a reason to give a medical exception. Um, and again, as Carlos said, the form is used in two different ways. One is to say, this person can answer questions about their own life. They know if they've been arrested or not. They know um, uh, where they went to school, but they can't learn new information because of their diagnosis. That's a person who should be granted an exception from the testing, the English and the civics, but who can still answer questions about their application and can still swear the oath of citizenship. The form can also be used for people who cannot answer questions about their own lives anymore, or never could because of a condition that they were born with. They should still be able to become citizens, but in that case, we also ask the doctor to indicate that they, because of their diagnosis, can't answer those types of questions, can't swear the oath for themselves. And in that case, a legal guardian or a US citizen relative who's related to them in certain ways and is also, one of their primary caregivers, someone who knows the details of their life, that person can go to the interview with them or instead of them and answer questions for them if USCS accepts the doctor's explanation. We if someone fails one of the English or the civics tests, they will be rescheduled to take it again within 90 days, which is great. You get I don't know if that increases your anxiety or decreases your anxiety. Either way, you get another opportunity. You get if somebody was not very serious about studying the first time, this tells them that this is not something that they can wing. The downside is you only get the second chance. So if you fail again, you need to go back to the beginning, file a new N-400 application for citizenship, pay the fee again um, uh, when you think you're ready. We used to have people who would, try to take the test the first time and fail, and then maybe come back to the second interview with a Form N-648 completed by their doctor. Having gone to their doctor and said, I studied, I tried, I failed. Is there something that you can say is going on medically? USCIS is not necessarily going to accept that now. I have heard mixed reports on whether they will accept an N-648 form brought to the second interview. Some will say no, it needed to be submitted with your N-400. So I can't recommend that strategy because the officer may not accept it. So if the person thinks that they are having problems learning the information, they should talk to their doctor while they're preparing their N-400 so that those things can be submitted together. All right, coming in on time. Here is our contact information. My email address, if this sparked questions. I'm not able to give personal legal advice, but I would be happy to answer general questions. And then, as you are probably familiar, the state has an Office for New Americans hotline, which is actually, I think, open 7 days a week now. And they have access to interpreters in something like 200 languages. So if anyone who needs resources related to immigration, related to citizenship, or is looking for other kinds of resources in their community, this is a great resource for them, especially because of the interpretation. So I know that many of you are not in the capital region, but there are ONA funds people like me and Carlos throughout the state. So if you direct your students to call the Office for New Americans hotline because they're looking for legal advice, let's say about their citizenship application, They will be directed to an ONA-funded resource that that may be us in the capital region, or maybe whoever has a job like ours, has funding like ours in your region. Let's see, I'm going to leave that up for another minute while give people a chance to write down my email address if needed, and the Office for New Americans hotline, though that is very Googleable. Thank you all for the work that you do. Thank you for working with new Americans, as I'm sure many of your students are. And the presentation recording will be available, and you have my email address there if you have questions. And there was a question in the chat about public charge. I knew that would generate questions. I don't think I can say a lot more here, but like I said, this is an area of interest for this administration. So I expect that as we see changes, there will be presentations available from me or many organizations trying to educate the community and hopefully alleviate some anxiety. So thank you again for the work that you do, and thanks for coming today.